Welcome to Thrive with Pride from Age Options, an online space for LGBT older adults and those who care for them. This is a recording of a live event held on Zoom, which included a lively Q&A that we did not record. After you watch, please fill out our end-of-year survey. The first 20 eligible participants will receive a $25 gift card as our way of saying thank you for your time. You can find the survey at www.thrivingwithpride.org/survey. This month, we hosted a training with Michael Stone, Legal Director for the Center for Disability and Elder Law, or CDEL, who spoke to us about the legal documents every LGBT older adult should have. See the video description below for more information about CDEL and a link to view Michael's slides as a PDF. So thank you all so much for being here. It's my pleasure to introduce Michael Stone, who is the Legal Director for the Center for Disability and Elder Law, where he ensures the high quality of CDEL's legal services, supervises the work of staff attorneys, interns, and volunteer attorneys, and manages the screening and placement of cases. Michael began his legal career at the law firm of Kirkland & Ellis as an associate attorney in the firm's corporate department. He later served as general counsel for the Cook County Assessor's Office and chief deputy assessor of the Cook County Assessor. He has also served as chief of staff of the Illinois State Toll Highway Authority. And prior to joining CDEL, Michael was an attorney in private practice. Michael has served as a keystone leader for the John D. and Catherine T. MacArthur Foundation's Preservation Compact, a MacArthur Foundation and Urban Land Institute-led task force on preserving affordable housing. He was also a member of Mayor Richard M. Daley's task force on property tax reform. Michael attended Harvard University as an undergraduate and earned his Juris Doctorate from the University of Chicago Law School. Thank you so much, Michael, for being here today. We're very pleased to have you. And the floor is yours.
Thank you, Kate. And my pronouns are he, him, his. As Kate said, I'm very excited to present to you a portion of information that we have available out there on advanced directives. I'm going to hit the highlights. If we were to do we do certain outreaches to the community where individuals are really looking to get advanced directives done or executed, and their next step would be working with an attorney. And a lot of these slides gives kind of background that's necessary for that kind of communication. But I'm going to hit the highlights today and encourage you to look at the slides that we'll be sending out later if you have further questions, or we can always be reached as well. First thing that we'd like to highlight on this opening slide, though, that this is for informational purposes only. We do not give legal advice over these sort of presentations. So if you are seeking legal advice, or if you have a question that starts drifting into the legal advice area, I will say that I can't answer that. And in order to answer those kinds of questions, we need you to be a client of ours. So with that said, the Center for Disability and Elder Law, or CDEL as we call ourselves, was founded 37 years ago now. And we provide free legal services to low income and moderate income individuals, and who are 60 years of age as seniors or elders, or a person living with a disability regardless of age. The need for our organization rose out of a brainchild of the Young Lawyers section of the Chicago Bar Association, which found three driving reasons to have an organization like ourselves. First is the level of poverty in Cook County in general. And the fact that those living in poverty experience legal issues more often than those not living in poverty. One legal problem will be experienced by 80% of those living in poverty. Second point is that disability affects 1 out of 5 Americans, and of those individuals who identify as having a disability, they also are more likely to engage the legal system. And then finally, which is probably no news to this group, there's an aging population in the United States. the percentage of those 60 and older is only increasing, and the needs and the legal needs for those individuals and all of us is only increasing. So as I said, the Center for Disability and Elder Law, CDEL, here's to provide free legal services to seniors and persons with disabilities who live in Chicago and Cook County, Illinois. We also have a second mission, which is to foster the spirit of pro bono service by partnering with volunteer attorneys, interns, which include students from undergraduate, paralegal schools, and law schools. So that they too will be in a position to provide free legal services throughout their careers. We're a relatively small organization staff-wise. We have a total of 12 individuals. But we, in 2020, closed nearly 1,400 files. And we couldn't do that without having partnering with volunteer attorneys and interns. So we are able to leverage our small staff to complete big numbers in terms of services completed. In order to be eligible for our services, you must be a resident of Cook County or an Illinois veteran, regardless of where you are in the state. You have to be over the age of 60 or a person living with a disability. We ask the individual to identify whether or not they are a person living with a disability. Low or moderate income, that depends on the service that you, what that means depends on the service that you're requesting due to the grants and other funding that we have. That number actually varies, but in general, that's about 200% of the federal poverty level. And you must have a legal issue that is within one of our practice areas, which I'll touch on in this slide. So we primarily do estate and end-of-life planning. Those are powers of attorney documents, which I'm going to talk about today, but also last will and testaments, transfer on death instruments, which is a way of transferring real estate without going through the probate process. We do other issues besides estate and end-of-life planning. We do home ownership issues, particularly in this time where housing is such a huge issue right now in terms of evictions and defending evictions, but other home ownership landlord-tenant matters as well, such as security deposit returns, conditions, reasonable accommodations for an individual's disability. We handled a number of other practice areas, simple divorces, meaning not involving spousal support or minor children. Collections and adult guardianship are a couple of other areas. What you don't see there is anything criminal on that list and other civil practice areas that we just don't practice in. So we have, this is part of our recent rebranding. We think of ourselves having 4 different programs that we deliver these services through. Adult guardianship being its own program and a separate help desk that normally operates at the Daily Center during non-COVID times, but has been operating remotely since the beginning of the pandemic. We offer power of attorney workshops, which is where this falls under, where we provide information to seniors about advanced directives like living wills and powers of attorney for healthcare and property, and then pair the senior or person with disability with an attorney to allow them to actually complete those documents in real time. And we have a specific project program for housing preservation, which really looks at the issues of heirship and how homes are being passed from one generation to the next. Unfortunately, in Cook County and just in general in the country, particularly in communities of color, there have been situations where the house is passed from generation to generation without making sure the proper person is on the title. That can create all kinds of situations, including an ability to access equity and other issues that happen down the line. We work to be proactive in correcting those problems, as well as a plan for the next generation. And then we have a number of community clinics we have out there. The senior legal assistant clinics are 10 locations throughout the Cook County that we previously had open during the pandemic in person, beginning in January of 2022. We'll be reopening and relaunching those sites. But we also have some specific affirming spaces. Proud to Thrive is a specific program for the LGBT community that is in the center on Halsted currently, as well as a specific veteran legal clinic in the Jesse Brown VA Medical Center and the Hines VA Medical Centers. So this group might be familiar with Disrupting Disparities report. I am not sure if everyone is seeing that link right now. If Kate, if you could just give me a heads up that you can see the report.
We are not looking at it right now. We're looking at the link to it.
No. Okay, I'll talk about the report then. The Disrupting Disparities report is a report that was created by SAGE and AARP that really documents really thoroughly and for the first time in Illinois the aging LGBT community needs, disparities between the LGBT elder community and the non-LGBT community. It provides a lot of data, a lot of issue spotting, and really a call to action about to address these issues. I certainly invite you all to read the report. It has it really affirms some of the things that our communities have been talking about for a while in terms of the LGBT elder community, that it's growing, that their needs are there, that it is something to be addressed. So please do check it out. But a few of the things that it affirms that in that report that we have been talking about for a while is that there are a lot of LGBT elders out there. You know, by our estimates, 56,000 live in the city of Chicago alone, and 3 million live in the United States. There are special needs for the LGBT community that are not that are different than the non-LGBT community. You know, the LGBT community is more likely to experience financial marginalization, social isolation, hesitancy about accessing senior services than non-LGBT elders, unless there are programs like this that are specifically directed at the LGBT community. It's the reason that we formed our own affirming a space at the Center on Halsted currently, and likely will be expanding to other locations so that we can provide direct legal services to the LGBT community in a space that is affirming, welcoming, and where a person can be themselves, but also not fear about repercussions because of their identity as an LGBT elder. So I'm going to hit the highlights about advanced directives in particular, and its impact on the LGBT community. So the system itself, when we talk about powers of attorney and living wills, it is heteronormative. And by that we mean that the legal landscape is set up for a traditional male, female, spousal arrangement with kids, and that system allows for decision making as and particularly as a person grows older or loses capacity, regardless of their age, and laws are in place to assist the heteronormative situation. It does not, however, address the LGBT community's needs, and particularly where individuals are wanting decision makers who are not part of a traditional heteronormative situation, whether that is a traditional spouse or traditional family making decisions on their behalves. So what kinds of directives are out there? There's a power of attorney for healthcare, which allows an agent, a person, to make decisions on an individual's behalf as if they were there, making them the decisions themselves. There's a power of attorney for property, which is in place for an individual to make financial decisions. A lot of people think that they don't have a lot, therefore they don't need a power of attorney for property, but it really does much more than that. For individuals, even without a lot of wealth, where they need someone to be able to make financial decisions, including accessing bank accounts and being able to pay bills like utilities and rent. There's the Illinois Living Will Declaration, which is a statement about how an individual wants to be treated in terms of medical care when they reach end of life. All three of those documents we draft and assist with here at CDEL for people seeking our legal services. A couple of other documents that we don't do, but others are sometimes seek. Mental health treatment declaration is for individuals who are experienced or who have experienced mental health issues. It allows someone to advance, determine how decisions should be made on their behalf, provided that they have capacity at the time that they execute that declaration. A couple that people are probably generally familiar with, the Illinois Do Not Resuscitate Order, or DNR. People in general almost always know what a DNR is, which is a Do Not Resuscitate Order, but a more expansive document, the POLST, P-O-L-S-T, or the Practitioner's Order for life-sustaining treatment, goes beyond what a DNR does in terms of those end-of-life, particularly those end-of-life decisions, or what treatment a person wants to have at the when they're in that situation. And then to throw in another document, which is really isn't an advanced directive, but the Illinois Healthcare Surrogacy Act. It determines how decisions are made when none of these documents are in place. So advanced planning is about doing things in advance. It has to be directed by the person who would be the subject of it. You cannot do things for another person. That means that your children can't do an advanced directive for you. You can't do one for your mom. It has to be the person who is going to be the subject creating the document. Which means always the question is, what happens if the person no longer has the capacity, the mental ability to make those decisions? That means that the person likely is going to need guardianship. So there's some big difference between a power of attorney and a guardianship. Power of attorney is set up to be very easy for a person to do. It's a simple document that can be witnessed and executed. It doesn't take away rights, any rights away, and it's only effective when the person choosing to create the document chooses it to be effective. Guardianships are a court process. We do assist with those, but they're time consuming and costly. And it does, at least technically, require that the person subject to the guardianship, the ward, be adjudicated as disabled, and therefore their rights are curtailed or taken away. So something to keep in mind, and why we encourage people to act now, not wait, particularly when it comes to these advanced directives like powers of attorney. So power of attorney requires a principal, the person directing or signing the document, to name an agent, a person who will make decisions on their behalf, and who will take on a fiduciary duty to make those decisions according as if they were the principal making those decisions. It often provides for a successor agent, the person who would serve in place of the agent. And it always requires in Illinois one person at a time. We will often encounter individuals who say, I want to make all my children my agents. Well, only one can do it at a time, and you have to pick which one. So a little bit about the power of attorney for property and healthcare. We see that the property deals with assets, finances, healthcare deals with medical decisions. So who can serve as an agent? Anyone the principal chooses. So it doesn't have to be a family member. It can be a friend, it can be a faith leader, but the person must be at least 18 years old. They must be legally competent to make decisions. It cannot, however, be a primary physician or healthcare provider. That is a very different question than who should be the agent. It should be someone who's trustworthy. They have to be interested in serving in the role. They have to be organized because it requires record keeping. They must be able to honor the principal's wishes. They have to be someone of concern and not subject to undue influence. We will often have a situation where the person wants to name their oldest child to be their agent. Well, while that person may be capable, that's not always the person who should be the agent. It might be a different child because they have these qualities, or it might be a friend, someone who is capable of making these decisions and serving in this role. For the LGBT community in particular, it is often someone other than the oldest child or a family member.
Excuse me. I'm sorry. On that last slide, it said well-suited don't have to be the same people. Who don't have to be the same people as whom? I'm confused by that.
So it doesn't have to be the same, I'm not sure what I meant by that. It's the fact that they do have to be capable of making the decisions. It doesn't have to be a relative, or I think it's really what it's getting at. It doesn't have to really be a relative of the individual. So the power of attorney for property gives a lot of authority to the individual. All of these, the typical statutory form has a list of acts that an individual can do. This is the complete list from the statutory form. It's a very lengthy list of those actions that a person can do. It is something to keep in mind when an individual is looking to execute a power of attorney for property, because it is a very powerful document and allows them to do all those actions. If someone is unhappy with that list and there's something in addition to that list, we don't see it all that often, but you can add more to that list. You can also limit those powers. You can either strike specifically the item from that list, or you can have some specific language that limits the individual from the list. You can also provide in the power of attorney that the power can be delegated to a person of the individual's of the agent's choosing, in the event that the agent is not able to act. You sometimes see that when someone travels out of the country. You might want to have the ability to delegate to another individual, or it can, at the principal's choosing, it can be prohibited from delegation. Sometimes they provide for compensation of the agent, but also it's very possible that, and frequently, that it provides for no compensation. A power of attorney for property can be effective immediately, allowing a person to begin to make those decisions immediately upon signing, or it can be, there can be language that makes it effective at a later date. Typically what we see is when a doctor declares that the person no longer has capacity to make their own decisions, that's when a power of attorney goes in effect. Most power of attorneys for property will be effective until an individual's death, upon effective first when the person loses capacity, then terminates when a person passes away. But it can be written so that it terminates at an earlier date if someone regains capacity, for example, or whatever what the principal chooses. Power of attorney for healthcare provides for the ability of an agent to make decisions on the person's behalf in terms of health care. It also gives them access to documentation, medical records. It's a broad power that really also should be carefully considered when someone is deciding who should have the power of attorney for healthcare for an individual. It too can be written to be effective on different occasions, whether it's once the person no longer lacks capacity, or it can be effective immediately. Particularly what we often see is someone allowing an individual to have immediate access to health records, even if they're not making the decision. I'm just going to jump to the Illinois Living Will Declaration. It's a personal statement about life-sustaining treatment. Whether the document itself defines when the living will be in effect. Usually it indicates an individual is suffering from an incurable and irreversible condition or end of life situation. It will typically say that where death is imminent and death delaying procedures would only prolong life, then an individual will choose quality of life versus quantity, and those death delaying procedures would not move forward. It's an important statement because it provides great comfort to individuals who are in the position of making those decisions on someone's behalf. I myself have been in that situation a few times, unfortunately, where you're placed in the position of making decisions on someone else's behalf, and it is great comfort when someone has made the declaration, whether that is they're choosing quality over quantity, or if they're choosing quantity over quality, whatever the decision, communicating that to your loved ones and the persons in the position to make the decision provides a great solace during those very stressful times. We talked a little bit about the DNR. We're not going to go into it too much here. And here's the POLST, the POLST, an example. If you haven't seen one, but it'll be in the documents. I just wanted to finally touch on the Healthcare Surrogate Act, which determines who will make decision when these documents aren't in place. A healthcare provider must make a reasonable inquiry as to availability of these documents. So they have to ask if there's a power of attorney for healthcare. And if there isn't, then the law takes hold and it determines who gets to make the decision on a person's behalf. And this is the order in which the decision is made. First, it goes to the guardian, the patient's spouse, adult son or daughter, parent. It falls, the doctor is required to follow those orders. It's particularly important for the LGBT community to be aware of the Surrogacy Act. If, in particular, those are not the individuals you want making your health decisions in that order. We often find in the LGBT community that relationships are strained between parents and other family members, and they may not be an individual you want making decisions on your behalf. All the more reason to make sure that these documents are in place and reflect who you want to be the decision maker on your behalf. And with that, I think I probably went long, Kate, but I hope I hit the highlights, and I am open for questions if we have.
Thank you again to Michael Stone for a really informative presentation. Don't forget to see the video description below for more information about the Center for Disability and Elder Law, as well as a link to view his slides. We hope you'll join us for our next monthly event on Tuesday, December 28th, 2021. As we look forward to the new year, presenter Margaret Danilovich, PT, PhD, will be introducing us to ways to keep active and mobile at every stage and age of life. She will also be conducting free assessments at our live event to help you determine your risk of falling and think about solutions. See more information, including the link to join, at our website, www.thrivingwithpride.org, or see the video description below for a link to join and more. Thanks for watching, and please don't forget to fill out our year-end survey to claim your $25 gift card.